Hey everyone, Harry here to talk about today's important, welcome, and somewhat surprising decision by the United States Supreme Court in a Voting Rights Act case. Just to give a little background, so the Voting Rights Act, passed in the 60s among the juggernaut of civil rights laws, has really been the most important law for securing voting rights and especially preventing the abridgment of minority voting rights in the nation's history. Even up to the 60s, there were all kinds of reading requirements and subterfuges to try to dilute the strength of minority voting rights. And the Voting Rights Amendment, which was passed under Congress's special powers under the 14th Amendment, had one extremely important and most used provision, and that was Section 5. And Section 5 identified a dozen or so jurisdictions that had history of discrimination against minorities, and said, if you make any changes to your voting processes, you want to, all the things we might be familiar about that especially Republicans have done in recent years, distance of polling places, or how much you can do at mail voting or security boxes, all of that stuff, you've got to clear it with the Civil Rights Division in Washington. This really stuck in the craw of those jurisdictions, understandably, but year after year, or repeatedly as it came up, the Congress renewed this requirement up to a few years ago, when a challenge was made and the Supreme Court, notwithstanding that Congress had approved it, struck down Section 5, just said, boom, it's not a law anymore. It's based on these outdated assumptions from the 1960s. You've got to revive or renew those findings for Congress for it to keep, you basically have to repass the whole thing, which, is a very remote, basically wouldn't happen, even though Congress continued to approve it. So Section 5, the number one most important weapon against discrimination, especially by race and all kinds of voting things, gone. That leaves Section 2, which is a sort of freestanding requirement that says you cannot employ practices that discriminate against minorities. Practices or procedures that discriminate on the basis of different protected groups, but especially that's minorities. So it doesn't give you, the remedy is really for damages. So it matters. Today's case, Allen versus Milligan, was brought against an Atlanta redistricting. That state is 27% African American, and the controlling Republicans gerrymandered in such a way that the 27% African Americans basically have 1 out of 7 districts. They basically draw crazy lines to put all the African Americans in one strangely delineated section, so they only get 1, even though you would think they should at least have 2. I don't want to be too crass, and you don't need to be too crass about an assumption that minorities will always vote the same way or vote for Democrats, but this was a clear attempt to dilute and sort of cabin African Americans' vote to one district, which they win overwhelmingly, and then the other 6 go Republican. All right, there was an action against this, and it went to the Supreme Court in 2022, and the court used the shadow docket, which you've maybe been hearing about, to basically say the opinion striking it down, which had been authored by Trump judges. They froze it and invalidated it and put it on hold, as a result of which the 2022 election was done under the gerrymandered Atlanta map that had only 1 out of 7. In other words, they did that 1 out of 7. It was challenged. A court struck it down, but the Supreme Court, with bitter dissents from from Kagan, among others, said, nope, let's go back to where the legislature drew it, giving only one district to minority voters, and we'll deal with it later. So today is the time when they dealt with it later. And during the oral argument, people were left with the impression they were probably going to strike down Section 2 as well. Basically just negating the Voting Rights Act altogether. All right, so surprise, in a 5-4 decision authored by Chief Justice Roberts and joined by Justice Kavanaugh and, not surprisingly, Kagan, Sotomayor, and Jackson, the court upheld the original decision, striking down the gerrymandered map, putting it on hold. It was actually done under the legal standard for a stay, saying it looks like the challengers are going to win, so let's put it to the side and then we will adjudicate it. So the court's decision basically strikes it down. So happy day for a lot of people. They don't get rid of Section 2 of the Voting Rights Act. On the other hand, some people are already writing saying this pretty weak tea. I mean, because to have, even though it was expected, to have gone with the Alabama legislature here would have entailed a wiping the slate clean of like 50 years of Supreme Court jurisprudence, the big one in the 80s, the Thornburg versus Jingles case. So yes, they didn't get rid of it altogether, and they showed that it has some teeth and there's some way to get at sort of rank racial discrimination. We might have thought this court wouldn't do it, but they did. They did say, reinvigorate the basic principle, and they did decline to overturn decades of precedent. Justice Thomas, for 4 of the justices, including Barrett, which is a little bit foreboding, right? At this point, Alito, Gorsuch, no surprise, but Barrett on that side, Thomas issued a scathing 48-page dissent that said, basically not just wrong, but horrifically wrong. But for today anyway, that didn't carry the day. So Section 2 of Voting Rights Act remains the law and gives some narrow opening for challengers to say that states have totally gerrymandered illegally by diluting racial representation. And that'll probably almost certainly means an extra minority majority seat in minority majority, referring to districts that have a majority of minorities in them, in Alabama, probably Georgia, maybe Texas. So just in practical terms, the 2024 election will probably include reconfigured maps to hew to the Supreme Court's decision today, and that will mean 3, 4, 5, 6, 7 seats that are much more likely to go Democrat in the South. And that itself, those numbers, given the razor thin margins that people have been dealing with, including now, is of independent political significance. So there you have it. Supreme Court, to many people's surprise, doesn't strike down Section 2, but allows and doesn't do what would have been a very dramatic radical act of getting rid of 50 years of jurisprudence, and Section 2 remains the law of the land. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.